Family law deals with the various relationships between family members, including husband and wife, parents and children, and more recently, same-sex partners. The need for family law usually begins with the marriage breakdown, the grounds for divorce. The Constitution Act of 1867 gives the federal government authority to define the essentials of marriage and the provincial governments the jurisdiction over the solemnization of marriage, the procedures required for a legal marriage. For many years, the traditional nuclear family was the dominant model for most homes. A nuclear family consisted of a mother, father, and their children. Over the years, this model has become less dominant, and several newer models have emerged to create a diversity among families that is unprecedented. Newer family models include same-sex couples with children, single parents, married couples without children, unmarried couples in common law relationships, and most recently, three-parent families. Marriage is a legally binding contract between two people. A divorce terminates this contract. Similar to other contracts, each spouse has rights and obligations. Each spouse has the right to live in the family home. Spouses have a mutual obligation of financial support and an individual obligation of self-support. Spouses have rights to share in an estate. One spouse gains the right to the estate if the other spouse dies. If there are children, the partners must determine care, custody, and support in the event of a divorce. Most of the essential requirements of marriage are recognized through common law, and each province has its own marriage act. The essential requirements of marriage are mental capacity, genuine consent, minimum age, close relationships, and unmarried status. For a marriage to be legal, each person must have the mental capacity to understand the nature of the marriage. Someone who lacks mental capacity because of illness, drugs, or alcohol cannot legally marry. A marriage is not valid if either person did not freely consent or agree to being married. If either person is under duress, that is, forced to marry, or if there is a mistake, marrying the wrong twin or a communication problem, the marriage is not legal. In Canada, the English common law minimum ages for marriage have been adopted: 14-year-olds for males and 12-year-olds for females. Females are 2 years younger because girls were thought to mature faster. However, each province has its own version of the minimum age, all of which are higher than the common law ages except for Quebec. Very young people who wish to be married require their parents' permission by law. In Canada, a person cannot marry someone who is closely related to him or her. A man cannot marry his mother, daughter, sister or half-sister, grandmother or granddaughter. A woman cannot marry her father, son, brother or half-brother, grandfather or grandson. Close relationships include adoptions. Both persons must be unmarried at the time of their ceremony. In Canada, monogamy, being married to one person, is the only legal form of marriage. Bigamy means being married to two people at the same time and is illegal. Polygamy means being married to two or more people at the same time, and it is also illegal. If a person wants to remarry, that person must prove that his or her previous marriage has officially ended. The formal requirements of marriage, known as solemnization, include issuing a marriage license or banns, performing the marriage ceremony, establishing age requirements, and registering the marriage officially. The banns of marriage refers to an announcement of an intended marriage read in a couple's church. A ceremony may be civil or religious. Before a wedding, a couple will obtain a marriage license, and following the ceremony, they receive a marriage certificate that registers their marriage. In 2005, the federal government passed the Civil Marriage Act, which changed the previous definition of marriage, which was the lawful union of one man and one woman to the exclusion of all others, to include same-sex couples. The definition now speaks of the lawful union of two persons instead of one man and one woman. Gay men and lesbian women successfully used their Section 15 equality rights in the Charter of Rights and Freedoms to have the definition changed. One of the spouses, usually the wife, may choose to change his or her surname. The options are assuming the spouse's surname, assuming a combination of one's own surname and the spouse's surname with a hyphen between, keeping one's own surname and not changing it. Each province has a Change of Name Act. Today it is common for women to keep their own surnames or combine them with their spouse's surnames.